All right, welcome back, everybody. We are going to get started with panel 4. I was saying to some of you over lunch that it's always a little bit hard to know exactly how to slice and dice the knowledge and topics in the room. We're calling this panel New Technologies, New Challenges. Probably you've noticed that some of the presentations so far are touching on some of the new technologies that this panel will dig into even deeper. So with that, I will turn it over to our first panelist, Barry Suleiman.
Thank you so much. So I know it's like sort of the post-lunch lull. Just to explain a bit about what this paper is, it's looking, or the chapter's about, it's about AI-selected embryos, their status and accountability. And what I was interested in was AI being involved in embryo selection. The concern that I have is not about AI turning embryos into persons. This is not a personhood sort of presentation, and I've sort of copped out of that because my brain does not operate at that level of intellect. But my concern is when software materially influences transfer, freezing, or discard, and how responsibility is distributed in ways ordinary embryo law doesn't capture. I've called this AIVF. So there's a bit of a problem with that sort of phrasing, and I struggled with it. AIVF, artificial intelligence vitro fertilization, artificial in vitro fertilization. I could call it AIIVF, but then it would be IVF, and I'd sound Scottish, and that's a problem because I'm English. So I just settled on AIVF and went with it. So as I said, I'm not getting into debates about whether the involvement of AI makes the embryo a legal person. What I'm arguing is that it changes the governance status of embryo decisions, and so the duties around selection become thicker in this environment. So I'm interested in that surrounding network of legal duties. And so where the legal issues arise, not every use of AI in a fertility clinic is morally problematic or interesting for that matter. So you can have AI for administrative uses, for example, for scheduling, billing, inventory management. These raise different sort of legal concerns from a system that ranks embryos for transfer, cryopreservation, or discard. And so the threshold I've applied is material influence. So once AI meaningfully affects what happens to an embryo, then I think we're no longer talking about ordinary efficiency. We're talking about a system that might help decide which embryo gets the chance to become a child. So what does AIVF actually do? So it deals basically with the practical question of which embryo should be transferred, which should be frozen, which should be deprioritized, and which should be discarded. Traditional assessments are already a skilled comparative judgment. Embryologists look at a range of factors to determine which embryo to transfer, and they may rely on time-lapse imaging, which adds a rich stream of information, capturing images every few minutes while the embryo develops. And that's very attractive for AI because there are many images and data points for AI to analyze, and it can help sort embryos against each other. And that's where I think the legal stakes sharpen. And so what I'm interested in is where AI is just part of the background process, and when it moves forward into materially influencing the choice of which embryo gets selected. And now the uses of AI in this space are broadening to automating the entire IVF process itself in some studies and technologies that are being developed. So is this really an issue? I think it is an issue. I wouldn't want to oversell it. AI and the use of IVF, we don't see it in every clinic, and there aren't really enough empirical studies in this space, but there are concrete examples. For example, there's a protocol EVA, which was given de novo classification, vitro life, kids score D3, which was cleared through the 510K pathway, fertility's Chloe Blast, it was also cleared through the 510K pathway. And the important point is when these devices are approved, they are framed as an adjunctive tool. So they provide supplementary information after independent morphological assessment rather than formally replacing an embryologist. And so that adjunctive label, it helps the industry and regulators, but I think it's too thin if the score materially influences the actual choice. A score can be called supplemental and still shape the outcome in practice. And there's also questions about how useful, how good these are in practice at leading to live births, if that's the metric that you're looking at. And so there are authorities in Europe, in the EU and the UK, which do cast doubt on the effectiveness of these tools, which I think also raise the stakes a little bit more. So that's my focus. I think that the move that I'm making is to say that AIVF creates a relational shift. The law should respond to duties around selection rather than declaring a new ontological status. And responsibility in this arena becomes harder. Traditional embryology decisions are difficult, but they're at least visible. You can attribute a decision to professional judgment, but with AIVF, the ranking might be shaped by training data, hidden correlations, data set limits, model updates, and design choices that neither the patient nor clinicians can easily see, and that disperses responsibility. The embryologist does remain central, but you have developers, data curators, manufacturers, procurement committees, clinic governance processes, and they all feed into the ultimate decision. And so this is why I think an ordinary liability analysis becomes a bit thin. And post-obs leads to two bad extremes, in my view. So on the one hand, you've got, we've ended up down the path, and I don't want to restate too much of what's already been said, but LePage, for example, the legal question was whether frozen embryos counted as children under Alabama's law. And I think that's the first bad extreme. If every embryo was treated as a child for wrongful death purposes, ordinary IVF practice can suddenly look like a big legal exposure. And for where AI comes in, that gets harder. If an algorithm ranks one embryo higher than another, and the lower ranked embryo is frozen or discarded, who's responsible? Is it the embryologist? Is it the clinic? Is it the developer, the data provider? And so I think there are consequences for going down that path, but so too the other path of blanket immunity. Or I should qualify blanket immunity a bit, but there is immunity in this space. And so the problem with immunity resolutions is that then you can't find out about the algorithm and why it made a decision, and developers can sort of protect or insulate their product from further scrutiny. And so I think some middle path is needed here for when AI materially influences whether an embryo is transferred and so on. I think developers should be responsible for design, validation, labeling, training, data, and performance claims. Clinics should be responsible for procurement, monitoring, and governance, and clinicians should remain responsible for informed consent and independent judgment. And so to sort of frame that, I brought in some of my other work, and I know time is so tight here, but I'll just briefly touch on this, and perhaps I can go into it more in Q&A. I've written elsewhere about how I think AI needs to be governed by what I call a true life cycle approach, which looks at AI from research and design in the very early stages to deployment through to approvals from regulators to deployment in clinical practice, and who's responsible at each stage there. And so I think that at the research and development stage for such devices, there should be an embryo selection impact assessment. When they're approved to market, they should be approved at least as high-risk devices. In clinical use, I think patients should be informed of when AI is used, and there should be logs and data collected of its use and when it influenced a decision. And perhaps even, and this is a bit more out there, but perhaps forming an ethics oversight board for the harder ethical questions for the use of such technologies in practice. And in the chapter that I wrote, I framed this around this true life cycle approach. And just to briefly touch on in the last minute that I have, so this is to really get details and data. So an impact assessment in the R&D stage would reveal, well, what data trained the model? What endpoint was being optimized? Is it live birth? Is it the health of the baby? Has the system been externally validated? Could it privilege certain traits which could lead to issues? And can humans override the decision? And in consent, and use what I argue in the chapter is that patients should know when AI is materially influencing embryo ranking. And so I'm going to stop there. It's gone red, so I don't think it's fair for me to go on further. But just to say, I think here, if we segment issues around personhood and just focus on process for a while, I think there are these concrete legal issues which we can bring greater clarity to in this space. So I'll hand over to Glenn now, who will be going into a sort of a corollary area on PGT.
Thank you, Barry.
Don't start the timer until I button up my jacket, otherwise I'm going to be in trouble from the fashion police. 1 sec. All right, that looks good. I think we can start now. Well, hello, everybody. Good to see you again. First, want to acknowledge people in the room who've written about this stuff. Dove, Sonia, also Susanna, and Jin Park, who I've kind of worked with on some related issues. These are just disclosures. Always good to start there. Starting point for me is we're talking here about polygenic risk scores. What are these? Well, for most major human diseases, doctors have estimated disease risk using factors identified in large population studies before. The big difference, though, is that these polygenic risk scores are calculated based on genetic variants identified through genome-wide association studies, so GWAS, and they've emerged as a potential breakthrough in disease and risk assessment, cardiac in particular, but also oncology and elsewhere. In this chapter in particular, if you have a 2x2, which is embryo, adult, and disease versus trait, those are continua to be clear. This chapter is really about diseases and embryos, the use of these scores, but some of what I say has implications for other stuff. So how are these PRSs constructed? Well, I only have 10 minutes, so I'm not going to tell you much about it. For embryos, essentially, what we're going to be doing will be in post-fertilization with pre-implantation. A batch of embryos derived through IVF would be genotyped using DNA microarrays or sequencing. Polygenic risk score would be created. That information would be provided to the embryologist, the patient, the parents, and then a decision would be made on implantation. And actually, the math is pretty complicated. So here's just to say, wow, math, right? To say, not important, but just to say, actually pretty complicated to actually do. But I want to get into what's interesting ethically and legally in my 10 minutes, which is to say, here's another way to say there's actually a lot of different methods out there for constructing these. And again, quite interesting as a scientific matter. But for the stuff that's interesting to us, the chapter first discusses how they are like or not like existing PGT. And in the chapter I go through this in some detail. I'm not going to go through it here, but just basically PGT much better validated. These are relative risks, not absolute risks. We're not focused on lethal or severely disabling. We're focused on a much broader swath of information. And this produces some interesting ethical questions. In terms of its relationship to the eugenics debates, or debates about the weasel word, as someone said about eugenics, my own take is that the dial goes up a little or down a little bit, depending on why you think selection is problematic under some things. Another way of putting it is my friend Michael Sandel is less happy. My friend Julian Sabulescu is more happy with polygenic risk scores than they were with the prior variation of this that we had for monogenic. But here's where I really want to start talking in a little bit more depth, right? And that is to say, compared to PGT, PRS has a lot of problems with accuracy. Here are a few ways in which it's less accurate or there's a problem. First, the amount of heritability from a polygenic risk score can predict varies much more significantly by disorder, and it's not always very impressive. It's often a small rounding error here. The second is the fit of the embryo to the underlying data in the GWAS is much more important here than it has been in traditional tests we've used. So the question of how close the subject is to the GWAS population is really important. And indeed, and sorry to show a lot of figures, but this is a good paper from Kolko from 2026 talking about population genetic drift and evolutionary history and how that influences the underlying scores for polygenic risk score distribution across continents and regions. So actually, your ancestry is probably much more predictive for polygenic risk scores, how good the score is. And that is a big difference. What makes these scores hard to communicate to patients, especially for embryo selection, is they generate relative risk scores. That's your relative risk as to the population. Even seemingly large increases in relative risk scores or reductions in risk scores often translate into only small absolute benefits or harms when it comes to the incidence of the disease in the population, because the incidence of the disease in the population is quite small to begin with. That's going to complicate advising parents significantly. Imagine trying to say this percentage change in schizophrenia versus this percentage change in diabetes as between these two embryos. Now let me layer on 17 other disorders, and now let me mix in trade information about educational attainment and the like. The idea that people are going to be making wise choices with this information, to me, is quite difficult. Also, there's a slightly different problem when a parent is deciding not between two embryos, but whether, in fact, to go for another round of IVF and generate new embryos. We know, because most of these embryos are coming from the same parents, actually the bounds in which the new set of embryos will be different in terms of the polygenic risk score is probably going to be small. And yet, hope springs eternal to parents, and they might think we're going to get a better chance if we go another time. Finally, in monogenic disease screened for using PGT, the disease is detected to have a predictable phenotypic presentation. By contrast with complex polygenic disorders and prediction, there's a large continuity of phenotypic presentation, and there's a real flattening of the presentation and what you can tell patients and parents, depending on what the source of the input data is and also what our expectations are on the back end. The current US regulatory regime for this, in a word, sucks. And here's what I mean by that technical term. I do go into some detail. That's not where I leave it in the chapter, but I go into some detail in the chapter. Turns out FDA's regime for regarding these as the testing regime is not very developed, and actually litigation over the lab-developed test rule that was struck down and then not appealed makes it worse. We do have the CLIA regime about analytical validity, but actually not well suited for what we need the law to do. In theory, FTC could do more work in this space. In reality, they're very unlikely to do so. And oh, by the way, the problem gets worse because we also have issues about updating data over time. So what do you do when actually you're given one polygenic risk scores about your embryos, then 5 years later, because of additional GWAS data, new methods and the like, the score would be quite different. This is an interesting problem of regulatory design. In the chapter, we argue that one analogy we can take is actually to AI and to change control plans that FDA has suggested for AI regulation, but it's not a perfect fit and it's difficult. Well, where does that leave us? Well, the possibility of tort law. So could tort law help? I won't say it sucks, but not quite as much as maybe you'd want tort law to help in this respect. Why? It's going to be quite difficult to actually articulate what the standard of care is for polygenic risk scores, to say that an interpretation or construction of a score was negligent. The standard is very much up in the air. The update problem I've already mentioned means that we don't need to just evaluate what was known about a particular PRS at the time, but also what was known about the quality of that score, the likelihood of change, how that was or was not communicated to prospective parents. Difficulties in determining who should have liability, the test maker, the doctor who performed the analysis, the genetic counselor or other person who helped interpret the data. How do we assign liability here? And then specifically in the embryo context, there are some interesting issues that are somewhat familiar from elsewhere in this space that pop up in an interesting way, in my opinion, in polygenic risk scores. The first is to return to something we've talked about before, wrongful birth and wrongful life. Wrongful birth, much more recognized in the United States than wrongful life. At the threshold matter, some states that recognize these claims limit them to misconduct after the pregnancy has started, not preconception, and that in itself might rule out some of the PRS claims. Polygenic risk scores, unlike PGT, are often focused on chronic diseases that are likely to manifest closer to the end or middle of life, such as diabetes, heart disease, breast cancer. that's going to create some interesting statutes of limitations problems where they don't show up for a long time, and even worse so if you have a statute of repose where you can't take advantage of a discovery rule, for example. The damages measure for wrongful death may also cause problems because typically when it is warded, it's like raising the child till age 18, but these disorders may only manifest much later in life after the covered period. So that's going to create a deterrence gap in terms of being able to deter, and also possibly a compensation gap, depending what you think the ill is. Then there's a whole category of cases that are not well covered by existing tort law. And that is cases not for allegedly negligent PRS that leads to the selection of an embryo you should not have selected if the test was better, but actually instances where the PRS advises discard or non-use, and as a result, you don't implant. So what's interesting here is it's fairly rare in the United States for prospective parents to choose to discard an embryo based on the result of a genetic test. Instead, they're much more likely to continue to cryopreserve them. But then what happens if you later determine that actually it was an error not to implant? How do we think about the damages measure there and the tort theory available to you? What does it mean if it was a better embryo that you might have chosen to implant had you had the information? Is that a cognizable tort claim if the one you had was healthy and there's no problem? Is it a cognizable court claim if you're now at a stage when you get the corrected PRS score that would have been delivered, where you now realize you would have liked to implant that embryo, but now you've aged out of your own reproductive plans? How do we think about this entire category? And more generally, and I'll stop here, how do we deal with problems of proof and detection? How exactly would a parent be able to know or to show that a PRS score is incorrect if it's never implanted? We're talking about a hypothetical about what could have occurred. Now, sometimes these things will change in terms of industry standards, but my own view is that there's actually a big gap in tort law here and one worth thinking about. Thank you very much.
Thank you, Glenn. Our next speaker is Emma Waters.
Good afternoon, everyone. It's a pleasure to be here with you today. Again, thank you to Glenn and those who have organized this wonderful conference and discussion. So my paper is entitled Neither Person Nor Property, dealing with the core question that at the heart of every legal dispute governing human embryos, and particularly frozen human embryos, lies a question that we have not coherently or consistently answered in law, which is, what exactly is the human embryo? And so after Dobbs displaced Roe, and with the near total absence of a single governing federal state or federal or state legislation, the judicial branch has been forced into an outsized role, resolving negligence cases, divorces, disputes over leftover human embryos, and broken contracts on a case-by-case basis. And so the result is a legal landscape best described as a patchwork approach, where outcomes turn not on any coherent theory of what a human embryo is per se, but on contingent factors such as jurisdiction, prior agreement, the competing interests of parents or the state, and even the embryo's physical location. And so the particular governing frameworks have focused on location, process, and intent, which are mere practical proxies that sidestep the deeper ontological question entirely of what is this entity that we're dealing with. And of course, we've heard other talks dealing with particular aspects of intent or location, but I really want to ask the bigger question that lies at the bottom, or really at the basis of this discussion today, which is, what is this entity that we are all debating and discussing, and how should we think about it going forward? So in the paper, I rely on developmental systems theory, which describes the human embryo as a self-organizing human organism, a coordinated network of molecular and cellular activity, directing its own growth from conception onwards. It's not a potential human life, such as egg or sperm. It is a human life at an early stage of a continuous process, a genetically complete and distinct part of the human species. This is what differentiates it from, say, the current models of synthetic embryos that we've heard about and discussed. And it's also what enables us to do this level of polygenic testing that Glenn just addressed. How else can we discern potentially up to 2,000 different conditions if it is not genetically complete and distinct? Now, having said that, I think that one of the points that can be the most hotly debated part of the discussion is that in taking a clear stance on what a human embryo is, it is assumed that there is a single moral standing that must be agreed upon after that. And so if fertilization is the clearest non-arbitrary line between the egg and sperm now becoming a human embryo, this doesn't mean that every person will agree on the legal or moral status of that human embryo. So oftentimes when I say that the human embryo is a genetically complete and distinct human being, the response is, well, that's mere ideology and therefore is discounted as such. But if that's mere ideology, then so is any other position that we hold about when life has value, whether it's at implantation or 20 weeks or at birth. So I want to press us to push a little bit deeper beyond some of those initial rebuttals and think about, well, what is the human person? And then we can ask the question, well, what are the legal and moral values we should attribute to it? And today, one of the interesting things that has really stood out to me is that there seems to be two big categories that we are dancing around with the question of the human embryo. And that is one that defines the human embryo by proxies. So the human embryo can have a different meaning or definition or value based on its intent, location, or how it was made. And then the second approach, which tends to insist that there should be an inherent definition of what the human embryo is in order to build a coherent governance structure. Even if we continue to disagree about where exactly that line of protection falls, it's a difference between should it be based on proxies or some inherent understanding altogether. Now, we have talked a lot about Roe and about Dobbs, so I will avoid recovering that ground. But I wanted to briefly just address the three principal approaches that the courts have taken to governing frozen embryo disputes. There's the contractual approach, the contemporaneous mutual consent model, and the balancing test. In practice today, what we tend to see is a contract first, balancing test as default. But what was so striking to me in reading many of these cases is that there was never a clear answer in even the judicial cases about what the human embryo is, merely what are the frameworks to which we can govern this human embryo is really where the conversation went. And then in particular, I wanted to bring in LePage to the discussion and dig a little deeper than some of our conversation has. And so in the LePage decision, the Alabama Supreme Court held that the act applies to all unborn children, regardless of their location, without exception based on the developmental stage, physical location, or any other ancillary characteristics. And then the LePage decision in particular presents a hypothetical that inspired my paper here today. And so in that decision, it said that under the clinic's logic, even a full-term infant gestated to term in vitro would not qualify as a child or person if it were developed in an artificial womb, based on the logic of the case. And we'll get into that briefly. So in particular, in the LePage decision, the trial court initially dismissed the case from the plaintiffs, holding that the human embryos did not fit the definition of a person or child. Nonetheless, the Alabama Supreme Court reversed this, holding that the act applies to all unborn children, as I just said. As the majority opinion noted, all of the parties in the Alabama case, the defendants, fertility clinics, and the parents themselves, agreed that an unborn child is a genetically unique human being whose life begins at fertilization and ends at death, and that an unborn child usually qualifies as a human life, a human being, or a person, as those words are used in ordinary conversation, going back to I believe it was John Evans' remarks about the sociological framework. What do people actually think of when they hear these words in relation to the human embryo and a child? But the disagreement arose given that the defendants, the fertility clinic, argued that the court should recognize an unwritten exception for embryos not physically in utero. The court declined, however, given its decision to logically extend the wrongful death of a minor child statute's protection from the moment of fertilization in the womb to human embryos from the moment of fertilization ex vivo. It is at this juncture that the Alabama Supreme Court made an interesting observation about the nature of the human embryo as it relates to the artificial womb. And so in particular, they said that if they were to agree to the defendant's logic, then even a full-term infant conceived through IVF and gestated to term in an in vitro environment would not qualify as a child or person, because that child would be both unborn, having never been delivered from a biological womb, and two, not in utero. And so such children's lives would be wholly unprotected by Alabama law. And that conclusion, the court argued, would offend the Equal Protection Clause of the 14th Amendment, which prohibits distinctions between citizens solely because of their ancestry that are by the very nature odious to a free people, heavily quoted from the Alabama decision. And so this brings us to the question of emerging technologies and how they press us to think more carefully about the status of the human embryo, namely artificial womb technology, in vitro gametogenesis, and synthetic human embryos. For the sake of time, I'll just make a few comments about the artificial womb. And so in artificial womb debates and technology, there's already the same question that we see in the human embryo debate. Do we consider the child gestated in an artificial womb as a gestling, a patient, property, or is it a person? And many of the same debates are playing out with lots of disagreement in this space. And what becomes very challenging is that a fetus at 28 weeks in an artificial womb would have very different rights under our current governing framework as a fetus in the womb of a biological woman at this point. And so we could come to the conclusion that the child, as they come out of the artificial womb, would simply, under born alive rules, become a human person. But it doesn't actually answer the question of what is the status of that developing human embryo to human fetus in an artificial womb should something go wrong, if there's a failure or if someone attacks the artificial womb. At that point, how do we actually govern and think about the nature of the human embryo, the human fetus, in an artificial dynamic, since our laws have largely been based on questions of fertilization or in utero or in biological womb, which don't really account for the developments that we're seeing in artificial womb technology itself. And so with the temptation with artificial womb technology, as with synthetic biology and IVG, is to focus on the potential future benefit of a given technology or course of experimentation. The decision to build embryo law on relational properties, such as location, process, intention, rather than any principled account of the developing organism itself, has created a legal dynamic that is untenable going forward as these reproductive technologies continue to develop. And so to wrap up here, artificial womb technology dissolves the location proxy. In vitro gametogenesis dissolves the process proxy, as we no longer have independent egg and sperm, but genetically modified human skin cells. And then stem cell-based synthetic embryos dissolve both, while also eliminating the fertilization anchor that underlies every existing legal definition. And so any framework built on these proxies is not merely incomplete, it is structurally incapable of extension to the world that the reproductive biotechnology is already creating. So in response to that, I put forward a technology-neutral framework that I would love to chat more about in Q&A, because that specifically deals with how we think about governing the human embryo with a coherent understanding of the human embryo based on the United Kingdom and Germany, while also allowing for these developments or potential developments in biotechnology. Thank you.
Thank you. And our next speaker is Vasiliki.
Alrighty, good afternoon. I expect when you signed up to go to an embryo law and ethics conference, you didn't bargain for a crash course on aerospace law, and from a non-lawyer, no less, but here we are. So the paper that I am presenting today, really, it stems from a research ethics consult that my colleagues and I led as part of a NASA-funded consult service where we interface directly with chief scientific officers at commercial spaceflight companies to help them navigate some of the ethical, legal, and social issues of the science that they were conducting, as well as just learn from a curiosity standpoint about what practices they were using to help them navigate those issues and address them moving forward. And so the claims we advance in the paper are deliberately modest, but I hope unsettling in some really interesting ways, and I'm really eager to discuss with you all. And in short, our argument is this, that human embryo research in space has a lot of legal precedent to draw from the terrestrial context. But the problem is that the guidance is really spread across too many legal regimes and too many laws at once. So on the one hand, we have international space treaties, namely the Outer Space Treaty of 1967, that gives us a really helpful framework for assigning things like state responsibility and international cooperation in this research, while domestic embryo law gives us rules about things like consent, permissible research uses of embryos, and in some jurisdictions, the bright limit of the 14-day rule. But what we don't have is a nice legal bridge and enforcement mechanisms between those two systems for off-Earth reproductive research. So I always like to start with the punchline so I don't leave anybody in a heightened state of anticipation. So ultimately, our paper gives several recommendations, what we think are really low-hanging fruit to fill some of these regulatory gaps, essentially to provide these ethical safeguards for emerging research in this space, and would love to hear from all of you about some other legal instruments we might be able to leverage for this purpose. And so first, all our recommendations principally rest on the establishment and enforcement of basic human research protections in the commercial spaceflight industry. So there is literally none at the moment, and so we sort of need to get on the first rung of the ladder with that recommendation. Our next is really to follow from the state of the science. So there's, everything we've talked about today, it's this profound realization that all of our scientific understanding of human embryo research is terrestrially dependent. The very early and incomplete kind of evidence base we have is that human embryo development, gamete development, everything is transformed in spaceflight, mostly because of the exposures to environmental exposures like radiation, the enormous G-forces it takes to travel to space in the first place, and principally microgravity. It completely changes the way the embryonic process unfolds, and then the organization of cells after that. We argue that not all is entirely new here, and we think much of the extant guidance can really be applicable in the space context, and chief among those, a primary, at this point, moratorium on implantation of space-based embryo fertilization. So just to give sort of a high-level overview and give some context here, so over 700 people have flown to space, but we've never had any verified human conception, pregnancy, or birth has ever occurred in space. And that's sort of reassuring to know. But both government-backed scientific and space agencies, as well as commercial companies alike, have developed these long-term plans that actually implicitly depend on our ability to sustain human populations beyond Earth, and making this whole scientific inquiry around human biology and reproduction a really foundational issue for future human settlements. At the same time, we have this limited scientific evidence base that suggests that reproduction in space, as I said, is extraordinarily different than on Earth. One of the most recent studies that was just published in March of this year reported that microgravity environments leads to approximately 30% reduction in successful fertilization of embryos, and they used non-human animal embryos, primarily mice, for that experiment, and we observed developmental abnormalities in those embryos that were exposed to prolonged microgravity conditions. But should there ever be a successful human fertilization event, there's an astronomical void, pun intended, in the regulation of such research in the commercial spaceflight sector. In the United States, we are currently under a congressional moratorium on regulation of occupant health and safety in commercial spaceflight. So the FAA regulates lots of other things, but the one major omission in its regulatory purview is actually occupant health and safety, so that the crew that are inside those vehicles, it regulates everything else around it, is principally missing. And spaceflight has a long history of global cooperation and scientific sharing. So the Outer Space Treaty, under multiple articles, outlines this international aspiration. It's quite an aspirational document to read it, especially now. It was signed and ratified by almost 118 countries at this point, including some of the major spacefaring countries, including Russia, China, and the United States. Yet at the same time, we have some of these discrepancies with domestic laws around human research protections. So in the paper, we outline at least 4 really overarching legal challenges and propose how we might manage them. So the first challenge we face is simply a biological uncertainty one, that our preliminary evidence suggests there's potential effects on things like sperm navigation and embryo development, but that evidence base is definitely very premature, and we think that it's this uncertainty that justifies support for a distinction between non-implantation scientific study and reproductive use. We also anticipate scaling some of these jurisdictional complexities. We highlight how space-based embryo research exacerbates certain jurisdictional ambiguities that arise from the Outer Space Treaty. So that's namely laws that cover things like source jurisdiction, the law of the registered object, the law of funding, and the law of the operator. These can be all applicable laws, but that totally conflict on a payload in low Earth orbit or beyond, and without any way of really prioritizing among them. We also observe some of the limits of consent here too. So private human spaceflight law, again, at least in the United States, is structurally oriented towards launch safety, and as I mentioned, omits protections for occupant health. And this is consequential, we think, for autonomy and certainly for informed consent. Knowing the known unknowns and the unknown unknowns really are heightened and amplified in the space context. And then this very controversial issue around space-born people. And that is the issue that we're raising in terms of this ambiguity in legal status of people that are born from fertilized embryos that were fertilized in space, and some of these ambitions that we're seeing of commercial companies raise questions about future citizenship and other legal statuses of fetuses that are fertilized in space. And so, these are a few of our recommendations. The first really being to extend and enforce standards for human research protections with, in black, some of the challenges that we already identify. So in the US, extending common rule protections to commercial companies that are currently exempt if they don't accept federal funds. And in the global context, some of the potential for conflicting regulatory requirements with other space agencies and the jurisdiction. This is the jurisdictional scaling problem. We think the evidence base is particularly small, hindering informed consent, but we think this whole process needs to be changed and adapted to consent rules that are unique to research in this area. And then respecting the international moratorium against the implantation of fertilized embryos that were fertilized in space until the safety and evidence base continues. And I'm going to leave you with a few really inspiring photos of the most recent Artemis mission.
Thank you.
All right. Hopefully it won't be too boring to bring everybody back down to earth. So first of all, thanks to Glenn and to Carter and to the whole team for including me. This paper, this presentation is attached to a paper that doesn't yet exist and won't primarily be written by me. And what relationship the talk will bear to the paper is TBD. But the slot is for my colleague Sheila Jasanoff, with whom I collaborate very extensively on things related to this issue. So please count this as an interlude and an invitation for further discussion if you're interested. Okay, so I'm going to talk about human genome editing, the application of the new sort of decade-old technologies of very precise genetic modification to human embryos. And I want to say a couple of framing things. First of all, this is a thing that has been anticipated since the advent of IVF, arguably earlier. In a sense, the discussions began in earnest at that point, and they kind of stalled. And part of what I want to do is give a picture of how we think about technological change and its governance, and perhaps then why they stalled. Second, I want to say that IVF is the platform upon which this possibility rests. The fact of the sort of infrastructure of IVF, which is technological and biomedical, but it's also sort of social, legal, cultural, et cetera. That is the sort of substrate upon which this becomes a thinkable possibility. And the third thing I want to say is that I'm going to talk about a technology, but the way I think about a technology from my field of science and technology studies is not an object in isolation that is a sort of focus of regulation or governance or whatever, but is always already embedded. And so one has to think norms, one has to think markets, one has to think practices, one has to think moral imagination, et cetera, et cetera. And what I want to discuss is the sort of some habits of thought that have shaped the trajectory of this field, have shaped ideas of its governability or ungovernability, and sort of create the situation that we are in today with regard to how those questions get addressed. And law in particular is what I want to think about, how the law is understood and approached. So this is from The Guardian a couple of days ago. Our fearless leader, Glenn Cohen, actually figures in this. He's not the Ken to biotech Barbie. He's better dressed, actually. But the key thing I want you to see is the headline. There's no way to stop this, okay? So what I want to talk about are conceptions of the kind of ungovernability of this technology, background notions of this impotency of law to contend with it, which are startling given the fact that if you want a biotechnology around which there's well-established black-letter law, the heritable interventions in the genome is a pretty well-occupied territory. But the ways of thinking about law and law's insufficiency to contend with a technology that sort of drives itself, as I'll show you, functions as a sort of self-fulfilling prophecy. So those are the things that I want you to see. And so first I want to talk about this discourse of inevitability, this notion of inevitability that was present there in that headline. Presumably everybody is aware of this case in China, and now 6 or 7 years ago. But the headline, again, here is the key thing, that this was a rogue and transgressive act. That's how it's characterized, and yet at the same time, it was inevitable. When discussions of this technology began in sort of 2015, Nature Biotechnology conducted a kind of survey, a sort of interview with the leading thinkers in the domain, scientific and bioethical and so forth. And this was the first question in the interview. Do you think it's inevitable that it will be applied to the germline? And like 70% of the respondents, including people including a future Nobel laureate for the development of CRISPR-Cas9 and so forth, answered yes, basically yes. Back of this notion of inevitability are notions like this, that science moves so fast that society can't keep up. The law lag, technology races ahead, law lags behind. And in a sense, this is built into our bioethical discourse. Advances in science and technology raise ethical questions. Here is the president of the US National Academy of Sciences, at the release of a report that John Evans was one of the co-authors of. It's a kind of a truism. But it functions as a sort of an authorization, this notion of inevitability. Agents who take action are not agential because they're simply actors in a kind of predetermined history. Here is He Jiankui, the Chinese scientist who produced the Chinese CRISPR babies. This is from an interview that I conducted with him while he was under house arrest in December of 2018 before he was shipped off to a Chinese prison for his transgression. If we're waiting for society to reach a consensus, it's never going to happen. But once one or a couple of scientists makes the first kid, it's safe and healthy, then the entire society, including science, ethics, and law, will be accelerated. It will speed up and make new rules. In a sense, he's telling a history, and he's quite self-consciously telling a history of the field of reproductive technology as such, where you kind of innovate first and ask questions later. The introduction of the technology into the market, initially controversial, becomes widespread, it becomes established, and there's a sort of normative shift that comes after the fact. The society accommodates itself. And in a sense, the discussions of law, at least some of them that we've been having today, are kind of in that mode. But a corollary in this case is the notion that the place of law as laggard is not only inevitable, but necessary. That you can basically get inhibition, or you can get a position of laggardness. You can foil it, or you can play catch up. And so much of the discourse has been about the kind of presumptive impossibility of arriving at any sort of shared judgment about what limits there should be, particularly at the international level. And this is a kind of a characterization, I believe she now writes for Wired, of the sort of state of play, which is just actually a completely false representation of the state of affairs in the world, in which a significant number of countries have legal prohibitions against heritable genetic engineering. But there's a kind of representation of law and the incapacity of law to contend with this radical novelty that is part of the sort of discursive milieu around the question of what should be done. Interestingly, this very prominent piece of international law, which since 1997 has had this provision as one of its 26 provisions, a prohibition against heritable genetic changes to the human genome, has been sort of oddly absent, oddly sidelined in discussions of how to govern this emerging technology, which is to say, it's as if the swath of the world that has taken itself out of the running, 29 countries have signed and ratified this convention, kind of don't count. It's as if they're not there. Last piece I want to talk about is the kind of imperative that attaches to this notion of the impossibility of arriving at proactive regimes of governance that are a kind of acquiescence to sovereign technology, an acceptance of a technological future, where one can make address sort of problems around the edge, but one can't stop it. So this is Jennifer Doudna, the inventor of CRISPR-Cas9, a year after the CRISPR baby, saying, we should give up on the idea of even a moratorium, a temporary limit, and just simply accept it and thoughtfully craft regulations of the technology without stifling it. There's been a kind of shift in the last year or so out of a more public kind of national academies of science-led conversation into entrance in the private sector, of whom this Kathy Tai that I began with is one. It's hard to tell whether there's a there in her case. In this case, this is a company that is actually pretty well funded. He is a Jennifer Doudna trainee. I visited him a few months ago in South San Francisco, where he has set up shop. And the thing I want to draw attention to is this is a company that's not only engaging in technological innovation around heritable genome editing, where the project is to commercialize the editing of embryos as a reproductive technology, but it's also positioning itself as an essential contribution to governance, as an essential contribution to an ethical conversation, as sort of as a sort of regulator of this domain, where its task is to evaluate whether it can ever be done safely. it's positioned itself as a kind of a gatekeeper. And the character of scientific developments that are continuing to unfold, people may have seen the preprint that was posted in the New York Times article that accompanied it for the work of Dieter Egli at Columbia 2 weeks ago, something like that. But I just want to pull two things out of this report. One is the selection of targets. One of them is a gene, PCSK9, which is implicated in cholesterol metabolism. The other one is a gene associated with fetal hemoglobin expression. The fetal hemoglobin expression is the target that is used in the now commercialized somatic gene therapies like Casgevy for treating sickle cell disease. And PCSK9 is a matter of significant interest because statins are in an absolutely enormous market and there's a potential to disrupt that market, right? So the notion is these are just sort of scientifically interesting sites of intervention. This is pure science. But you know, it's done in the context of a commercial background. And these are genes which have a kind of commercial potential that, you know, it sort of strains credulity to say that that isn't part of the background. And indeed, one of the partners in this is Nucleus Genomics, which, you know, is a polygenic screening company plus, and, you know, one of its representatives is quoted in the article talking about the genetic optimization stack of which this technology is part. So to just sort of to conclude there, I want to point out, number one, there's a construction of the possible and impossible forms of governance. Number two, that positions the imperative of technological innovation and the sort of authorization of a kind of technological vanguard to position itself as playing that governing role. And number three, the vision is of a commercial enterprise which is made in the image of the American IVF industry that's unfolded over the course of the last 50 years. I'm not going to say anything about this last quote except to tell you that this is the explanation written in a letter to a Chinese court from one of the couples that participated in He Jiankui's experiment, explaining why they participated. This dealt with HIV in a country in which AIDS is profoundly stigmatized. So it's worth thinking about what exactly is getting governed by this kind of technology. Okay, sorry, I went over.
Thank you to this panel. It's an extraordinary sort of buffet of topics to dig into together. I'm going to start on this side and move around. I see Vince. I don't think anyone before Vince. All right.
Thanks, everyone. This was really great. I'm really interested in how pluralism or just different opinions fits in here. So Emma, I find your argument very, very compelling. And then I kind of get uncomfortable because then I think, well, if I find it compelling, then at what level is it acceptable? Like, is it state level or country level? Or at what point is there an imperative for us to enforce this on other countries? And Vasiliki, is that my pronouncing that right?
Excellent.
Okay. To the space point, too, is to what extent, should we reflect pluralism in space? What if space is only occupied by, libertarian tech bros in the future? Should we just allow it to be a kind of a libertarian frontier? Or if the moon is Democrats and Mars is Republicans, should we kind of allow those two different things to play out? I'm kind of curious to what extent we tolerate these things.
Thank you, Vince. I'm going to do a full Carter-Snead method here and take all comments moving around the room this way, and then let the panel have time to respond to what they think is most important. John.
Yeah, so this is for Ben, and we'll talk. But when I think about what is it that leads someone to say this is inevitable, can't be stopped, et cetera, I mean, part of the explanation for at least why it seems to be on a slippery slope with absolutely no restraint whatsoever is the fact that bioethics and law and science is unwilling to put up any barriers, no matter how far down the slope, because of the need to, in the logic of bioethical debate, to say we need to have the absolute most current science to know what's possible, et cetera, because of the sort of calculative nature of American ethics. And so therefore, unwilling to build barriers way down the slope, I'm sure to these entrepreneurs, it's inevitable, it can't be stopped, et cetera. Now, whether or not it can truly be stopped forevermore, different question, but I think that's part of it.
Thanks. We're moving backwards. That was not the plan. No, go ahead, Josh. Sorry.
My question is for Emma. I think this room, like, there's clearly so many different perspectives and so much expertise that we have. And I think that one of the things that I find myself thinking of listening to your presentation is the points at which, like, regulation should or could take place. And so one of those places is conception, birth, which most people would probably disagree is way too late, or somewhere in between that point in time. I think a lot of our country finds themselves like in this political divide where they find themselves into one bucket, probably one of two buckets, at which point regulation should take place. And I think that there's the personhood aspects to it, which sort of render this relational discussion that we've heard about where the embryo exists moot, because we see the embryo itself as life. But then I think that there's also the difference of the special consideration framework that treats embryos as potentiality for life. And so I think that there needs to be more conversations, and I wonder what your take is on it about, like, what kinds of things you think need to take place in order for us to be able to address these really challenging and nuanced questions, especially when we have experts in the room and also people with sociological and surveying expertise to be able to see how people view embryonic life or embryos. And so I just wanted to offer that.
Thank you.
Hi, my question is for Emma. Emma, I think that we may agree on something, which is that Dobbs is a bad decision. My read of your work would conclude that since we have this patchwork, as Dobbs, the justices articulated in Dobbs, that they're returning the issue to the states, my read of your work would say that it's almost a critique of Dobbs in that way, because you think that's a problem. And so I guess my question to you is, do I read that correctly? That at its core is I think your argument is that if you could rewrite Dobbs, you would have gone further to perhaps make personhood, legal personhood declared by the court in that case. But I was, so tell me if we both agree that Dobbs is a bad decision.
Thank you.
Thank you for such an interesting panel. My question's for Benjamin. I'm really interested in this kind of idea of inevitability that's becoming much more of a mainstream discussion in the context of AI. All these interviews with AI CEOs who are kind of alleging it's inevitable. And I'm wondering if you think at all, or to what degree, the mainstreaming of that inevitability discourse has the potential to bleed into these technologies that are much more kind of out of reach than AI is for the average day-to-day consumer who's watching it kind of bleed into their lives. So I'm curious to hear your thoughts.
Quick one for Emma. The paper that we read or heard about this morning, the Halid-Bertinsky chapter, argues that wrongful death style liability for embryo destruction can have unintended consequences like chilling assisted reproduction, and most practices there foreclosing consumer protection claims. I wonder how you would deal with that accountability gap within your framework.
I guess I'm the only one who comes from China, so I want to offer two comments from a Chinese perspective. First, Emma, your point that embryo is neither person nor property. I think our civil code, the new provision of the embryo's legal status is exactly what you said. So it said that embryo is a very unique object which has the personhood meaning. So you might want to take a look at that provision. Is provision 1183. I don't advocate for that provision, but I guess you might be interested in how it plays out in a country, even though the country is very different from the United States. And for Benjamin, I think I totally agree with you that the impotency of law. So first, what I want to offer is the new situation post the scandal. First, we have a new criminal provision which prohibits the implantation of embryo which has been genetically edited. So that is a very new change in our criminal code. And we also held some workshops, conferences with Nuffield Council from UK and from France to have international organizations on that issue. But I agree with you the impotency of law. So I was wondering, we know that law is unpowerful in regulating this kind of very bad behavior. So is there a way out? I'm a very pessimistic person, but I also want to know, if strengthened ethical review can be a way, or anything that we can do to prevent that. Thank you.
Thank you for the lovely panel.
I just want to jump in to say, if all people have questions, that's great, but then the questions need to shrink.
I will have two very short questions, and I also just wanted to start by saying I'm happy to just stalk you in the break if it's too many to answer, so no worries about that. I actually had two. One for Emma, bit of a curiosity question. I was really intrigued by what you mentioned about the definition of an unborn child, and I was wondering what that might imply for monozygotic twins, considering that their genetic copies. And then a question for Vasiliki. I'm sorry, I'm probably mispronouncing. I was just out of curiosity also wondering whether the legal precedents that you mentioned that would be relevant for embryo research in space would also be relevant for research with embryo models, which I believe is also starting to occur. Thank you.
So my question's for Glenn. So you mentioned, or it was at least listed on the slide, that despite all of the kind of problems and complexities regarding the polygenic risk scores, that nonetheless regulating them too much or prohibiting their use would be worse because of the risks to personal autonomy. At least that's what I interpreted from the bullet points, so maybe not. But the question, and maybe it's a false premise, is if these scores are so complicated and we know how bad people are at decision making that requires kind of sophisticated statistical understandings of risk, to what extent does this knowledge actually further autonomous decision making, or might it actually, in some sense, undermine it just by confusing people with information that they can't really grasp the significance of?
Others on this side.
So I loved all of the presentations, but I limit myself to a question for Ben, which is this notion of inevitability and impossibility. I mean, we saw that with the internet, Section 230, and the AI conversation. And so I was interested, do you think it's sort of distinct in some ways in the sort of the biology context? And if it's not, and the second piece of that is it being driven perhaps by the companies that don't want to be regulated, right? And so it's sort of, indeed, that's the whole point.
Great panel. I have a few questions, but I'll just do one for Glenn. So I was interested in the choice of terminology that you called it PRS, not PES or PGTP, and I didn't know if that was intentional, so it might be, I'm happy to chat with you afterwards about the best way to describe it. And then one thing I think was maybe implied but didn't really come out as strongly was you mentioned the consumer protection and the confusion for individuals seeking this testing. But it strikes me that there's one additional piece that really complicates this and I think makes it not really very valuable testing, is that not only are you dealing with relative risks, but you're dealing with relative risks within a bunch of embryos that are all genetically related. And so the variation of what you're going to get in value, it would be one thing if you were screening all the embryos of the entire world. And I think that's something that really needs to come up more strongly because it may make parents understand the real limitations of this kind of testing. And so maybe talk about that part a little bit more.
Hi, fabulous panel. Emma, my question is, of course, for you. I loved your paper, but you characterize location and method as proxies, and I wondered whether that sort of begs the question. In a sense, what an embryo is may actually depend upon how it was made or where it is. And an embryo inside the body that has implanted, that is connected, that is integrated with the woman's body is not the same thing as an embryo that's outside, just as a kidney that's been transplanted into and integrated into a person's body becomes a different thing from the kidney outside the body.
Thank you. Those are terrific questions. I'm going to give the panelists, why don't we start at the end with Vasiliki and we'll come this way. Take about a minute and then we'll have a break. So that's our motivation for timeliness.
Great. So in my notes, I have Republican Moon and Democratic Mars. And pluralism. So I really appreciate the question around pluralism, and I think it actually would be more welcomed at this stage because the way that I'm reading and many of the engagements I've had with commercial companies is that I worry about the space bro fantasy, and we talk about tech bros. There's definitely a typological space bro emerging as well, and I worry about that rhetoric and that mentality actually becoming cemented in what we think of the applications of this research in space. There have been tremendous scientific discoveries and technological advancements that originated in space that we now use on a daily basis now. Certainly your GPS and communication systems, but things like MRI machines and different medical devices that originated there. So I think where we should be actually, to Ben's point, kind of interrogating the inevitability of who gets to define what space research is and how we leverage what we learn from space on Earth. I think too much it's this view that the mission of human interplanetary existence, which is directly almost word for word the mission of SpaceX, is going unquestioned. And so I would actually really welcome more pluralism in that space. And I think among the academic circles, bioethics is actually very far behind. It's far behind in providing a perspective. It's far behind in helping to advance policy in this area. I think the environmental ethics community much more ahead of that. Really quickly, the other question around applicable legal precedents for embryo models, I actually think it's an even better fit because from a research standpoint, those models are more helpful in helping us understand some of the fundamental biology where the exposures and experiments would be unethical or impossible to do in an Earth analog. So even simulated microgravity only sort of gets us so far, and what we're really interested in are some of those environmental exposures that only space can show us. And I'll also point out that the latest Artemis mission actually flew a model, an organoid model. So this was Avatar, the astronaut virtual tissue analog response. It's called Avatar for short. So it was a stem cell derived from blood samples from each of the crew members, flew along with the Artemis crew along the 10-day mission. So one was on Artemis with them, one stayed on Earth, and those results are being analyzed as we speak.
Well. I've got a couple of questions to get to, and only at least one of you is trying to get me in trouble. Intentionally.
And Emma,
I'm sure I'll do that on my own. Okay, so A host of questions, somewhat interconnected, a few thoughts regarding them. I think when it comes to these questions of governing in vitro fertilization, which I do think per an earlier panel is distinct in important ways from our abortion debates, because we are dealing with a fundamentally different technology and fundamentally different questions about human life and governance. And I think it's important to keep the two separate because of that. And so when I approach these questions, I think the first one that we should think about is the question of what is our goal? When it comes to practicing in vitro fertilization, what is our goal? Is our goal to treat infertility, to help people have babies? Is it along the lines of polygenic screening, the attempt to help certain people have a certain kind of child? What is the goal that we have when we approach synthetic human embryos or artificial womb technology or IVG or some of these embryo experiments that we've debated today? And I think that the goal is maybe similar in some regards and yet very, very different in important ways, where there are very different intentions at play here that have to be addressed distinctly to fully understand and I think explore the different issues at play. So I don't want to merge all of those into one category, and certainly not all under the abortion category, because I think you're just dealing with wildly different issues and questions here. The second thing that I will say as a big picture remark is that it's always very striking to me, especially in recent years, that federal policy and even some state policies will outright avoid the question of defining a human embryo in the definitions section of federal text. That strikes me as very odd, to put it lightly, because ultimately if you were writing legislation dealing with assisted reproductive technology or a human embryo in research, the failure to define the thing to begin with means that we are going to be at fundamental imbalance in our ability to speak honestly about what we're doing. It seems unintentionally dishonest, if you will. And so I think that is also telling in its own way, because to define what a thing is seems like the basic expectation for any policy debate, and to avoid it tells me that there's some sort of discomfort even in saying that a human embryo is a human or a genetically complete and distinct human embryo. Well, why is that? And I think per our discussion, there is this sort of inherent sense that a human embryo can't merely be property. I don't think the special status category has actually held much water in the legal debates following, and yet there's a deep discomfort in saying personhood or saying that it is, a human being at the earliest stage of its continuous development. And why is there such a discomfort? I think that's where there's a level of reflection that needs to take place. And likewise, as the LePage decision pointed out, contrary to the defendant's initial claims, in many cases with public policy and with research, we start with we invert the proper sequence. So we say, if we say the human embryo is X, well, how will that impact the cost of IVF, the accessibility of IVF, the ability to do research, access to X, Y, or Z? And I think that fundamentally inverts the process. And this is the point LePage made, which is that we have to say what a human embryo is and then address the secondary concerns from it. These are not unreal concerns, they're very real concerns, but they can't overwhelm the inherent question of what is the human embryo. And the final top line point is that I, like Ben, am very interested in the relational impact of these technologies. So Marshall McLuhan, the 1960s bioethicist who wrote "The medium is the message," or the massage, as he says, rather provocatively, is he says that you cannot judge a given technology simply by what the technology does, but by the social and psychic consequences that it bears upon society. And so he uses the example of a railway, but similar to the context of IVF, you can't simply define IVF as the fertilization of a human egg by human sperm in a laboratory, but we have to actually ask the deeper question of how is this technology, the potential for technologies like artificial wombs, IVGs, and synthetic embryos, changing the way that we're thinking about what the human embryo is. And if we never begin with a clear definition of the human embryo, we're always going to be subject to the whims and pulls of each new technology. And that's really the heart of the paper, is that these developing technologies are already revealing the shortcomings in our current jurisprudence and definition of the human embryo. How much more complicated will that become when these technologies are actively at play, when synthetic embryos can actually mimic a human embryo to the point of potential personhood in a very serious way. And you're already seeing some of those debates play out with the surrogacy question and other areas. So then very briefly, Vincent, to your question of
Emma,
what...
can I interrupt? You're going to be very popular at the break, and so I'm
Okay.
going to ask you to stop so that we can finish and get to the break. And I hope people will gently let Emma get a snack and then talk to her then. Thank you.
Emma's always really popular. Listening to Vasiliki, I've changed my mind. I want to embrace inevitability and send all the tech bros to space. Let them be space bros and stay there, right? So let me try to answer several of the questions together in a little bit aphoristically, but we can talk at the break if you want. So companies don't make the narrative of inevitability. The narrative of inevitability makes companies. So it's not a conspiracy. It's what I would call an imaginary. It's a sort of shared imagination, a shared understanding that leads people to act and relate in particular ways that produces the forms of relations that they imagine are the relations. So if law lags behind, and law inevitably lags behind, and therefore that must sit on your hands and wait until technology comes to a place of development, like John said, that we're in a position to actually now see what ethical issues it raises so that we can address it. Oh, but wait a minute, the horse is out of the barn, and so there's nothing we can do. If we wanted to say, well, this is not a world we want to live in, too late. It's the world that we live in because we waited to react to it because we needed to wait to see what issues the technology raised. Of course, that is precisely how regulation of IVF in this country played out, in the sense that you had to have somebody who was, a gestational surrogate sue someone else, and they landed in court, and they had to have, we enact it. And so I think that one of the things to see with regard to genome editing is that it's unfolding in this sort of sensibility. It's intensifying it, it's concretizing it, it's attaching it to something, and is thereby kind of reinscribing it and accelerating it. And yeah, absolutely, this is the same story. It's the same movie playing out in the AI domain. And if one steps back and looks at it and looks at how much work the technology is racing ahead so fast that society can't keep up, does to keep society in a sort of position of being on its heels, well, you see that absolutely everywhere. What other domain would we have a guy walk into Congress, say, I'm developing a technology that has a 10% chance of extincting the human race, and Congress says, whoa, you know so much about it, why don't you regulate it? That's bizarre, right? And yet it's organized around this sort of narrative of inevitability and the notion that in this domain, law can't do naught but mess things up, basically. So proactive orientation is sort of unimaginable. And I was thinking, listening to Vince earlier today, that he was giving a really nice account of how when constraints were placed, it opened up a range of possibilities because there was a reorientation. The flow shifted slightly, and it kind of opened up a universe of creativity that might not have been invited but for the creation of a constraint. I'm not a lawyer, but isn't that contracts? Isn't much of law precisely about the production of social orders through the construction of constraints that anticipate people engaging in creative activities within the parameters of those constraints in ways that the producers of the constraints couldn't possibly imagine, but are reflections of the norms that are built into those constraints? And yet somehow it's like a disjunction with regard to science and technology. We can't think about it that way. And that is, we should think about the fact that we're incapable of thinking about it that way. Because after all, these are mundane human practices done by humans within social milieus, et cetera, et cetera. And with regard to that, just one final little comment, it seems to me that the starting point therefore matters. If you're preoccupied with the technology and what impact and consequences it might have, it's a very different question than saying, well, I'm preoccupied with human rights and human dignity. And what do human rights and human dignity demand? Well, maybe human rights demand that one is free to live a life that is not scripted by another, genetically scripted by another. Maybe there's a human right not to be genetically engineered. And it's altogether possible that the that under the framework of the Oviedo Convention, there will be a conversation about whether there are circumstances in which it's appropriate to engage in heritable genetic intervention, just like Germany went from categorical no pre-implantation genetic diagnosis to a very delimited set of very horrible diseases that are authorized. But it did it, and I would think that within a human rights frame, it would be done with that as the point of reference, as opposed to, is this a future in which this technology colonizes all things? Are there any things that we can do to tweak it at the margins to, hold it back here or hold it back there, make it a little bit safer, bring down the risk of extinction from 10% to 6% or whatever? It's a very strange way to commit ourselves to governing, but it's a commitment. We do it.
Thank you, Ben.
Great. My mother always told me I was delicious, but I wager the snacks are even more so I'm going to be very brief. Melissa, I just want to say, I am not a fan of these scores. I was more talking about the skepticism that anyone's going to do anything about it because the regulatory stuff. To Sonia with the terminology, I think I just used that because that's what I used to refer to the adult one and didn't intend anything to it. And I agree with you completely about the relative risks, but also the fact that it's a small thing if you're talking about your own embryos. I will say what to make of reveal preferences that companies are making a lot of money on pitching this is sort of interesting. And lastly, I want to thank Ben because if I had a job, it would be just beach.
I've got nothing to add, so I'm done.
All right. Thank you all. Let's have a round of applause for this panel, keeping the afternoon lively.